So if you are shy, you can turn your video off, not use your audio, not use your raise hand function. But we are going to record it, so some folks can get credit later. It won't be shared anywhere but in-house. Also, okay, and if you're attending today, please shoot Amy an email to let her know that you're here, so she can send you a copy of your certificate. And I gotta go down this way. Okay, so here's where we're going to go in the next couple of hours. I'm gonna speak to you about technology. I'm gonna talk about ESI, and I'm gonna talk about obligations to undertake diligent litigation holds. I'm going to talk a little bit about Zoom. Those slides will be a little bit dated because we've kicked the can down the road on this presentation a couple of times, and the ethical concerns are still out there for using Zoom, but Zoom has taken care of a lot of these themselves, these issues as they came up, recognizing the target audiences that where their product is used, particularly in the legal space. But nevertheless, a good opportunity to talk about what you might be thinking about while you're using Zoom. And then I'm going to talk a little bit about the Lawyer's Assistance Program and some of the, when we were first putting the slides together, you'll see that folks were really challenged by the times, and it had led to some statistic tracking about things that were happening to the general public and as well as to lawyers, and maybe some resources if you're feeling the stress of the times. Then I'll be talking about the ever popular lawyers behaving badly segment. And then we'll move on. And I think that next, that's Meg's segment. She's going to give us a year in ethical review with some ABA opinions, professional discipline cases. And I think Peter jumps in at some point in the middle of there. I think he does. Peter, what part are you jumping in on?
Go back one more slide.
Right there.
I've got the New Hampshire year in review. Yep.
Okay. And then Meg does the ABA opinions, correct?
That's correct.
Okay. Professional discipline cases, and then we might talk a little bit about who's the client in terms of our new time and billing software and new matter opening software. So let me jump right in with litigation holds and our old friend ESI. The initial questions, obviously, and I'm not going to read directly from the slides. It will be too long a morning if I do that. But I think everyone's familiar with the concept that electronically stored information is a real repository of critical information as litigation unfolds. And this set of slides is actually born of an experience that Elise, Trevor, and I had with a case where there were many reasons why the case resolved, but the sort of Damocles that was hanging over the parties during the mediation was a pending spoliation motion. So the cases can truly turn on issues arising out of ESI and the lawyer's conduct in preserving ESI in the litigation. So because this is an ethical CLE, we're going to start where we always start with the rules. And in particular, when it comes to technology, we always turn to Rule 1.1, which requires competent technology and specifically requires lawyers to understand techniques and practices, and the comments require lawyers to understand the risks and benefits associated with relevant technology. The idea of spoliation and the idea of the requirements to preserve ESI sort of arise, at least ethically, out of Rule 3.4, which requires fairness to opposing party and counsel. And obviously it's easy to understand where that comes from. If a party were either to let their client or not take steps to require their client to preserve important data that might be used, electronically stored information that might be relevant in the case, there should be an ethical consequence to that. And the ethical consequence arises out of Rule 3.4. Excuse me. There's also, and again, I know that there's folks on from multiple jurisdictions on our program today, as we are a regional law firm and a growing one at that. But in particular, just by way of example, Superior Court Rule 25 has actually addressed ESI. And it's very interesting because I find this particular rule very practical and very direct. I mean, the federal rules also address ESI, but I don't find the federal rules on the subject quite as instructive. I mean, the decisional law and the commentary under it and the practice under it certainly gets to the same point, but New Hampshire Superior Court rule really tells you what you have to do and it really tells you where the repositories of information should be sought. And it puts the burden on the lawyers to notify the parties to place a litigation hold. The threshold question is when, I mean, the Superior Court rules sort of speak about the idea that by the time you get to a Superior Court rule, there is already a lawsuit, but the obligation to preserve ESI may arise long before there actually is a lawsuit. And in particular, it might be the case that the duty to preserve arises before the litigation itself, as long as the litigation is reasonably foreseeable, and it may be the litigants themselves that trigger that by way of commentary. In the actually Meg, I forgot to say Meg was on the case with Elise and Trevor and I, and one of the things that we found in that case was there was a smoking gun email in which a party said, "What else do I have to do to be ready for litigation?" to their lawyer, and that we took the view that that was sufficient to trigger the obligation. So you have to be aware that maybe just not, it may be in the process of preparing your client or helping your client through a transaction, you may have a situation where if litigation is reasonably foreseeable, you in fact have a duty to make them take efforts to preserve data. So at this point, I think most of us are familiar with the concept of a litigation hold or litigation hold letter, and how that requires the party to do essentially three things, I think. One, to stop any kind of destruction, suspend the process of suspending routine destruction of data, stop the cycling out of backup tapes, to suspend the ability of a party or a person to destroy data. It may require you to take steps to preserve that data by segregating the files in a native format in a place. It may also, in certain circumstances, require a party to go out and to forensically image hard drives or other data where there are repositories of this. I think, and we'll talk about this a little bit later, the real challenge to me is it's easy to issue the litigation hold letter. The challenge is going back and talking to your client and actively taking a stance of saying, what do we have here? Taking the inventory after you send out the litigation hold letter. And Bill has, and he shared it in the past, and we have it somewhere around here. Bill has a really great inventory that's part of my litigation hold letter that asks, and it can be sent to multiple people within an organization, that asks them to take stock of the various places where they might have data. That's a challenge, but that's not impossible and it's not difficult. Where the rubber meets the road is when you have to say to your client, okay, now we're going to have to hire an outside agency or an outside vendor to come in and to preserve data or to image devices. Frequently, as this firm finds itself representing more than its fair share of defendants, that's an additional burden that's placed on a defendant that may or may not be covered by the carrier, or if the client is paying for the entirety of the litigation, that you're going to have to go out and get someone who's forensically skilled to undertake that challenge. Sometimes we've been able to use Chris and Matt in-house to do it, but that's not always the best course, in particular if the custodian or the person who's going to have to testify that the proper steps were taken is going to be a witness. There's a really fine line, and we encountered it in our case that I've been alluding to previously. Does that make the IT person or the paralegal who undertakes the preservation task at Sulloway and Hollis a witness in the case, or at the other law firm a witness in the case? So it may make some sense to go outside to undertake these tasks, but that's going to become an expense for the client. So a real challenge and a tightrope to walk, but the consequences of not doing it really can really change the landscape of the case and its ability to survive, or its need to settle, and how much it's going to settle for. So what steps do you have to take? I think I've jumped a slide here. Our old friend Cam Schilling, who never misses an opportunity to tell us all about ESI and electronic discovery, points out that data is dynamic, that if you don't grab it at your earliest possible opportunity, it may change. It may be the case that simply leaving the email in the Outlook spool may change that email. It may be that leaving the document in a document management system like WorldDocs, it may be altered, it may be audited, it may have all kinds of small fragments of information that are changed because we didn't take the opportunity, or a client didn't take the opportunity to grab a snapshot of what that data was and place it in a place where it is not going to be changed from that point. So, and the other point too is, if you don't grab it, sometimes the changes that can be made, if they are rather nefarious, are very difficult to detect. So, word to the wise. Here's a key concept that I think that's often lost, is that there's difference between spoliation and adverse inference. Spoliation is not the same thing as an adverse inference. And the Sedona Conference, which is sort of the place that we look to for a lot of definitions about ESI and a lot of definitions about what it means to practice in this space, takes the position that spoliation is really the destruction of documents and records and the property of them, including metadata. But an adverse inference was different. Adverse inference requires intent to the parties to either fail to preserve it or to otherwise prevent it from being used. So it is possible to have spoliation that does not result in an adverse inference. In New Hampshire, just by way of example, in order to get the adverse inference, you have to show that the party had control over the evidence, had an obligation to preserve it at the time it was destroyed. So usually the litigation hold letter is a good marker, or as we've been discussing before, a letter that or an email to counsel that says, what else do I need to know to prepare for future litigation? That's a marker in the sand, and that can set the timeline after which the party's destruction of the information is, if the party who destroys the evidence or the evidence is destroyed or spoliated, if they are on the other side of that time marker, that's going to be the first part of it in number one. The records destroyed had a culpable state of mind. Obviously going to be more difficult. You're never going to have a party say, yes, I destroyed it. Maybe they're going to put on their calendar, please wipe all email from my web email. That's going to be a good marker, but it's never going to be anything direct. And generally your evidence is going to be inferential. And you're going to have to show the third part is that what has been destroyed is going to be relevant to a party's claim or defense, such that the reasonable trier of fact could find that piece of missing evidence would support the claim or defense. Obviously not unlike many parts of New Hampshire law and the law of other jurisdictions, where there is a gap in our decisional law, we look to federal law, and there is a strong and robust body of federal law on ESI issues. So beyond the Superior Court duty, the Superior Court rules, we have an ongoing duty to maintain our technical competence. If you are going to be in a case, and it's hard to think of a case these days where there's not going to be a chain of email, where there's not going to be a series of Word documents which may tell the tale. So you've got to ask yourself at the outset, am I the kind of person who understands what ESI is, how to preserve it, how to get the best out of my client in terms of understanding what needs to be done. I see Rob has his hand raised. Rob, you want to jump in? Take yourself off mute.
Thanks, Kevin. I just have a question. I understand the ongoing duty to maintain our technological competence, which basically means I consult with you. But one of the issues that I'm curious to have your input on is the ongoing obligations to be communicating with clients on their duty to preserve not only electronic communications, but all other evidence. Because we certainly reach out to them with our hold letters and reach out and counsel them early on in the process. But I have found historically over time, they start to forget, and other departments, particularly if it's a larger organization, don't stay on board, and then they start deleting things when they do their every 6-month cleanup. Do you have a comment about how we address that issue? Thank you.
I think a couple of things jump to mind. First of all, is the need to sort of keep this on your mind, and whether you do that as a function of calendaring it at certain parts of the life cycle. But I think the other thing you'll find is it happens organically, as far as I'm concerned, that you put the litigation hold letter out almost as soon as you get the case. At some point when you have to do your mandatory disclosures, you're going to say, okay, do we have this stuff in native format? And that's a good check-in time. And then alternatively, when you're getting your native data back, it's probably another good time to think, do we have this information in a parallel space, in a parallel need? And just to go to as Irv might say, to look at the case that Meg, Elise, Trevor, and I had. As the case progressed, ESI became a bigger and bigger function of it. It was not, and in fact, opposing counsel made the point at some point at various points in their opposition that at the outset of the case, ESI probably wasn't that important and only became important as the case came by. So at those road marks, at those moments, it's another good point to check in and say, okay, how are we doing? Because you can imagine if you make ESI an issue with respect to your adversary, they're probably going to, even if just for badness, make it a problem in your life just because they want to, try to keep things parallel. So that's my thought.
Thank you.
Sure. Best practices, preserve early and often. Actually, Rob's question sort of segues well with this slide. Preserve early and often. Understand that you have an ongoing obligation. You have an obligation beyond just sending out that litigation hold letter, and it's important to have regular communication with your client about ESI. What I'm going to actually do is I'm going to jump through this set quickly. I don't think we're going to have a need for me to come back to it, but I always can. I think what you should take from this slide is same set of rules: 1.1 technical competence, 1.6 avoiding inadvertent and unauthorized disclosure, and your obligation under Comment 18 to safeguard information. And I think what you eventually come out, and you realize these slides are a little bit dated because we kicked the can down the road a couple of times with this presentation. So some of the issues that were relevant or were at the forefront in June of 2020 have been dealt with various upgrades and updates to Zoom. And maybe that's the big takeaway I want you to walk away from this is, to the extent to which you have ethical obligations in using technology like Zoom, update early and often. There's a little tab on Zoom that allows you to check to see if an update is available. The more you update, the more the greatest and latest security upgrades come into focus. I mean, for example, in June of 2020, we didn't have automatic passwords. We didn't have the waiting room function as a default function. Zoom bombing was something that was happening with greater frequency. So some of these have, you're going to get a little seasick while I go here. Sorry. Some of these issues have sort of resolved themselves. But I think that just sort of jump to the best practices, password protect anything that is going to be in particular a client meeting, refrain from recording teleconferences without consent. New Hampshire is a two-party consent jurisdiction when it comes to the wiretap statute. To the extent to which Zoom would qualify, I don't know. I don't have a particular opinion, but I would not want to record anyone, wiretap or otherwise, without telling them. And I think the other thing to do is maybe put that on a slide or give folks some notice that you're going to do that. Refrain from exchanging confidential exhibits through the software. I think that's more difficult sometimes. If you're going to have a robust conference, it's very convenient to be able to just to drop an exhibit or drop a document into the chat box and to pass it around. If something is truly confidential or something you don't want out there, you can do what I'm doing here, which is do a screen share and have folks look at the document rather than putting it in the chat box. The other piece of it too is to keep an eye it's difficult to do when you're the presenter, but if you are simply on or you're a co-counsel, always handy to take a look at the participants bar of Zoom to see who's on. That can also be awkward to challenge folks when they dial in on the phone line, say who's joining us, but obviously something important to do because you really have less control over dial-ins, and what you might think is a confidential conference may not be if there's other folks on the line. I kind of want to jump to this issue, which is it turns out, and I don't think this is a surprise to anyone, lawyers suffer at a greater rate from alcohol use, substance abuse, depression, and anxiety at a much higher rate than the general public does. I think it's sort of I think we all kind of know it, and it comes to our attention from time to time. And I don't think there's anything wrong with passing it on to folks here as a sort of a waypoint. Again, this was something that was coming about, by the way, and you may recall this from 2018, national news for a gentleman who grew up in New Hampshire, who was working at one of the big law firms, and really the pressure of working at an AmLaw 25 law firm caught up with him. He eventually took his own life, and his wife and some of his colleagues made it an opportunity to talk about what that can do if people don't get help. The impetus for bringing these slides in was the fact that stress was a real challenge when COVID-19, still is, even though we are opening up. I think some of the mental health challenges and some of the substance abuse challenges are wide ranging and will be with us for a while. So, these stats came out, and when they were part of the slides that we put together, but I don't think it's a surprise to anybody that there were increases in anxiety and alcohol and substance abuse issues and just consumption. And always a good time to think about what it might mean in your life or the life of a loved one. More stats that may be of interest to you. I'll let you leisurely review them. But here's the whole thing. If it's something that is a challenge for you or someone you know, especially as work from home continues to be a part of our lives, consider checking in on yourself, consider checking in on your loved ones. And there are resources. There are Brian Cuban, who Mark Cuban's brother, has been an advocate. He's got a very active Twitter site and LinkedIn presence, and really approached this issue with a great deal of compassion as well as a great deal of humor. And it's usually a good read when he has something to say. We as lawyers have, in particularly, a unique program, the New Hampshire Lawyer Assistance Program, that provides assistance for a wide variety of challenges that lawyers face, for lawyers, law students, and judges. The resources include professional functioning, mental health, recovery, suggestions how to keep busy while inside. They have a series of meetings which may be of value. Some of them are remote, some of them are in person. What I find, and we tend to think of the New Hampshire Lawyer Assistance Program as something that the Attorney Discipline Council, the ADO, brings in to bear when someone finds challenges. And of course, there's a chicken and the egg proposition there. The issue is sometimes, do lawyers get themselves in trouble because they may have some mental health issues or some substance abuse issues, or does the substance abuse issues become part of what the mental health issues become part of the challenge? So I'll just throw it out there. There's a slide out there. What you should know is they're always available to you by phone or by email. The good news is that there's a New Hampshire Supreme Court rule that provides for confidentiality for all client interactions, client meaning lawyer in this particular case. Any information disclosed is protected. Our administrative rules provide that protection. And in fact, if help is sought includes a violation of the rules of professional conduct, NHLAP will not be the entity that makes the report. They have a special carve out there, and they are there to help. So turning to a sort of, I was going to say a happier subject, but really, although some of these are entertaining, some of them actually dovetail with the second set of slides, but the always popular lawyers behaving badly segment. We have three for your consideration: the deposition destroyer, the profanity practitioner, and the legal lamprey. So Scott Zarin, the deposition destroyer. We've all encountered a variant of Scott in our practices, those of us who take depositions, just to sort of tie it in to make sure we get some credit. And although Sulaway and its practices and its traditions would never sanction this kind of conduct as being consistent with the way we choose to practice law, there are ethical rules other than reputational rules that make this kind of conduct impermissible. So 3.2, expediting litigation; 3.4, fairness to the other party; an additional obligation, of course, under Rule 30B, or Rule 30, requiring that essentially is the rules we all know, that even if you make an objection, it under only limited circumstances is that going to stop your client from having to answer the question. Let's look, as Marv Albert, the retiring Marv Albert, would say, let's go to the videotape. Here's the transcript that got Mr. Zarin in trouble, one of many. In particular, you can see he's at the beginning of the transcript. The questioning counsel, examining counsel, is asking about an individual. Zarin says it's irrelevant. but it's the name of a person on a tax return, which is relevant to the case. There's the usual tussle about examining counsel decides what order he's going to ask the questions, and then he asks whether the examining lawyer wants to know if Zarin is telling him not to answer. So as we all know, this page probably took the better part of 6 or 7 minutes to get through, and it's really just the tip of the iceberg. When the analysis of Zarin's transcript was done, he spoke in 75% of the transcript pages, suggesting ways for his client to answer under Rule 30D2. The court imposed sanctions because his conduct essentially destroyed the deposition, and Zarin and his clients had to pay half the costs of the deposition. Now, this one is Christopher Hook is a favorite of Peter. So if Peter wants to open up his mic and discuss this guy, you remember this guy? He had a great deal of traction in the news because his conduct went from bad to worse. Let's move ahead to some of what he did. The things that got him popped at the end of the day. Good old Rule 4.4: respect of the rights of other persons. The purpose of his conduct was to embarrass, delay, or burden. And again, there's a matching rule in 8.4 where the primary purpose of conduct is to embarrass or harass. And let's take a look at what he did. Here's a sample of his emails. I won't even try to do them justice. I'll enjoy it. You can guess what the words that have been blacked out are, or asterisked out. He was a character. The problem was counsel for, and I believe it was Allstate on the other side. The counsel for Allstate, like most of us, took it, and then at some point really just assembled the emails and submitted it as part of a motion, and that's when the court got involved. So, and there's video of this or audio of it. It is really a really challenging audio because Hook shows up at court. He shows up late. He starts mouthing back to the judge. The judge is obviously, Judge Wright is not happy, and in fact, during the hearing, asks Hook to resign from the bar. Not only does Hook refuse to resign from the bar, attempts to justify his conduct as zealous advocacy. And I think the interesting thing when you listen to the audio of it, Judge Wright was also not pleased with the client. I mean, he really was on the edge of saying, yes, the client does not understand our professional rules of conduct. Yes, our client is not behind the client's not behind the emails, but the client had knowledge of the emails. In this particular case, Hook was the plaintiff's counsel. And at some point, I think Judge Wright wrestled with the idea that they had some responsibility for their client's conduct. What came out later was eventually, and I don't know who got to Christopher Hook, it turned out that Hook ultimately did acknowledge that his conduct was, as he said, he exploded in anger stupidly. He had anger management and emotional problems. He had a loss in his immediate family. I think there may have been some substance abuse issues, and ultimately he sought help. So you can see how the two sets of slides are related. You know, when people face substance abuse issues, or when they face mental challenges or mental anxiety, you know, they can come out in their work and they can get themselves into trouble like this. So I can't remember how it resolved, but other than at this particular, I think the plaintiffs also replaced him as well. So Mr. Hook did not go gentle into that good night, but there's our old friend there. Now there's a character, Leibowitz, the legal lamprey. This is, and I think we're all familiar with lawyers like Leibowitz, who essentially his MO was he was prosecuting. He was a copyright troll, and I think he actually, one of his issues was he sued people for calling him a copyright troll. And essentially, he had these sort of long-term clients for which he had a certain amount of latitude to bring actions for copyright violations, but then he sort of stopped consulting with the client in terms of whether he was authorized to bring the action. And because he was making so much money sort of settling these cases for low money early on, what he was doing was just bringing actions and the clients didn't know. And the ratio of the ratio to frivolous versus meritorious actions ought to be 0 to 100. But to the extent to which he had questionable actions, it began to rise in the number of cases that actually had no merit and were simply filed in order to get quick settlements and nuisance settlements. And people began to catch on to him. And at some point, when just like in the Hook case, he got dimed out, and there was a motion made to the court, and it turned out that the court issued notice to the actual client not going through counsel. And when the client found out, they realized, as noted this time, 10 months had gone by, and it was the first time he had learned of the lawsuit. And and I'll take the client as word. It could be possible that the client was trying to put daylight between him and the legal lamprey, but at the end of the day, it turned out that the allegation was that the client didn't even know that the lawsuit was filed on the client's behalf. Just to bring it back to the rules, obviously 1.1 for competence, 1.4 for client communication, 3.1 for meritorious claims and contentions, 3.3 for candor towards the tribunal. And, before you think that this is too far gone, if I recall correctly, New Hampshire's decisional law bad faith standard arises in part out of a lawyer taking an appeal off a claim that was dismissed without the client's knowledge and against the client's wishes. So it's not, while these facts are entertaining in a certain sense, they are not that far gone from what can happen in New Hampshire practice. This is interesting. This is the order in the case where the judge says one might think that the lawyer with this kind of record would tread carefully, particularly before a judge who had recently sanctioned. But as the case makes clear, not Mr. Leibowitz, because he, like Mr. Hook, did not know, in the words of Kenny Rogers, know when to hold him or know when to fold him. He continued to be obnoxious to the court. And here's the actual excerpt from the letter that we had a brief bullet point of before. So in the face of that, at the time these slides were done, he was appealing the order, but it looked like he was in for $100,000. And the court accepted the client letter that the lawsuit was brought without his knowledge. And then before we could even get in trouble, here he was again. He hadn't learned anything in the Usherson case, and he continued to act poorly. Part of the sanctions required him to attend CLEs. He only attended some of them. The statement he submitted to the court was, as you see, riddled with typos and vague generalizations, and clear that he had simply cut and pasted course outlines to show what he learned. And then when given another chance, he only submitted the same document, again, with slight modifications. So I had 40 minutes. I come in at 38 minutes. So I will hand the baton over to Peter. I'm going to mute myself, but I'll stay on the line to move the slides.
Okay, I'll unmute myself and turn on my video. And yeah, what I'm hope to do with my section right now, as we've done in years past, is to provide a summary of some of the more important decisions that have come out of the Bar Ethics Committee in the last year. Not that they are necessarily the most important issues of the day, but they are what has come to the committee. They are what lawyers are communicating with us about, either directly in the case of inquiries, or sometimes just in looking for information or looking for consultations. So there are probably about 8 or 9 of these opinions that touch on a bunch of different areas, different variety, and they're just good reminders of the things we got to keep in mind as we go forward. And I'm going to try not to do an exhaustive analysis of each one, but just kind of give you the headlines, and if it's relevant and you want more information, you can certainly read the opinions. The first opinion that I want to talk about relates to disclosure of the identity of the client. And this actually turns out, it's an interesting issue because you really got, if you will, 2 parallel bodies of law relative to disclosure of information. And what I mean by that is you have the ethical rule 1.6, which says that, we're prohibited from disclosing information relating to representation without client consent. And, over in the litigation context, we've got the whole concept of privilege, attorney-client privilege. And what's important for people to keep in mind is that the two bodies of law are not in parallel, they're not in sync. And, just because something is no longer privileged, it does not mean that it is no longer subject to the rule to preserve client confidences under Rule 1.6. So the particular inquiry in this case dealt with does the disclosure of client identity violate 1.6? And the answer is yes, it does violate 1.6 unless it happens to fall under one of the exceptions for the rule, where you can look up the exceptions. They include uh, uh, disclosures necessary to defend yourself in a professional conduct claim, disclosures ordered by court, as well as, and I'll talk about a little bit later, uh, uh, implied consent to disclosure. So, your first reaction might be, oh my God, why is that, why can't we disclose client information? Because in the body of law about privilege, there are a lot of carve-outs where the client identity is not necessarily privileged. And where it comes from is, again, Rule 1.6 says we cannot reveal information related to the representation unless we fall within one of the exceptions of the rule. And the key here is the word information. Information is, by the body of law that interpret Rule 1.6, is defined very broadly as including everything that you learn relating to the representation. And client identity, of course, would be part of that. Just because um, information has become public, for instance, doesn't necessarily mean you can talk about it. Again, it's not like privilege, where if privilege is waived, all bets are off. So you might say, why so strict? And I think the rule is grounded in the whole body of law regarding confidentiality. The opinions talk about it being the hallmark of the attorney-client relationship. It's the bedrock upon which clients come to us and are confident in revealing their deepest and darkest secrets. And you might ask, well, why is revealing the identity of a client necessarily a problem? There are many situations in which identity could be very detrimental to a client's interests. Consider a member of a couple consulting a divorce lawyer about potential representation before anything is filed and before the spouse even knows. Obviously, it could be very negative repercussions. Similarly, if it gets out that a business has just retained the services of a well-known white-collar criminal lawyer, it could tip off the outside world to that the firm is engaged in some sort of sensitive internal investigation. There's another case or example where it's a firm that specialized in the representation of people with physical and mental impairments. Again, the idea of disclosing that you are one of their clients could be information you don't want out there necessarily. As I said, having said that, the rule does have numerous exceptions. You can disclose, where it's impliedly consented to by the client to carry out the representation. Obvious cases of this are, if they ask you to file suit, you got to disclose their name. If you're negotiating a business deal on behalf of the client, you're going to disclose the name. But the decisions, caution lawyers about not reading the implied authorization or implied consent language so broadly as to gut the rule. They note that you have to be constantly evaluating whether disclosing this information um, is reasonably within the consent that you have already received or feel that you've received from the client. And if not, double check it. Um, it's also, the opinion closes with a good cautionary note that 1.6 um, does, speaks to existing clients, but exact same rule applies to former clients under Rule 1.9. Duty to protect their confidences, and also to prospective clients. And I think, and Meg is going to be talking about an ABA opinion about prospective clients, but folks who call us for services, but with whom we eventually don't develop an attorney-client relationship, are referred to as prospective clients, and we owe the same duties to them as we do to clients in preserving confidential data. The next opinion that the ethics committee issued is one that Kevin will probably be footnoting all my comments and said he said this, but he really meant this during this. But I'll do my best. And the headline question that's teed up by this opinion is, can a lawyer use social media to review online social media accounts of potential jurors to find out information that might be helpful in the representation of the lawyer's client. The opinion, the headline of the opinion says, doing this kind of investigation can be very critical, can yield fruitful information, but lawyers have to be extremely careful when doing so. Specifically, it's Rule 3.5, prohibits ex parte communications, with a juror during proceedings. And this is read to include, potential jurors, as you're selecting a juror. And so the question becomes, all right, if you go out there and you find a social media account, what kind of what kind of actions trigger the finding that the lawyer has initiated a communication with the juror. Probably, the easiest one is, sending an access request or what they call, or say, geez, can I join your account? If you do it, that just straight up the client has, the juror has to answer. That's a pretty easy one. The decisions all say, nope, you can't do that. That's not acceptable. The decisions do, they say that yes, you can view publicly available information, where you don't have to submit a specific access request. So, you don't have to ask the client if you could be a friend or, whatever the particular vehicle is, requires the notation. However, the tricky issue arises with the fact that many of the social media services will provide the account holder with something I'll generically refer to as an access notification. A notification, so-and-so has just logged into your account. So-and-so has just checked into your account. There's actually, a split in decisions among jurisdictions across the country as to whether, a lawyer's accessing an account to get publicly available information without directly communicating with the juror, but in a situation where the juror is going to be told that the lawyer has accessed the account, whether that constitutes a communication. The ethics committee here in New Hampshire went with the body of cases that take the position that it is a communication, because it'll alerts the juror to the fact that you're looking at it. And in many cases the fact that a juror is being investigated by a particular firm, could be something that could chill a juror's interest in serving or influence the decision. And so the headline here is, this goes back to Kevin's comment. I think, we can't refer to Rule 1.1 too often, which is the rule that requires us to be sufficiently technologically savvy to do our job in 2021 and 22, and going forward, that we can't just say, I don't understand all that tech stuff, and that's beyond me. And if you don't understand it, you got to get your training, or if you do, or hire people who can provide you with the services. So in this case, the opinion follows a number of jurisdictions that say, lawyer, before using each particular type of media, even if you're looking at public information, you've got a duty to know whether or not that provider is going to tell the juror that you have accessed the information, and if that's going to happen, you shouldn't do it. There's also notation in the decision that in many of the you can block your ID, and so there is a potential you could block your ID and then access, and then the juror will never know that it was you looking at it. But again, speaking as somebody who not only can't use social media, media very much at all, but and would never know how to block my ID. It just underscores what you have to do. Something very important to remind people here too is the standard rule that a lawyer can't do through a third party what the lawyer can't do him or herself. So in our case, simply because we have a paralegal go on the social media account, and investigate the jurors, that doesn't protect us. We're responsible for what they do, and we're just as responsible if we ask them to make kind of a contact.
Peter, if I could just jump in, I think
Yep.
the Soloway Ethics Committee was confronted with something similar that we used this opinion for, and we took the position, I think one or more of us took the position that if you wanted to look, for example, at someone's LinkedIn profile, you had to go into your settings and change your settings so that the view would be considered anonymous, so that when the person got pinged, it wouldn't say Kevin O'Shea viewed your profile, as an adjunct to this sort of, both as not an end run against a represented party and as not an end run against providing notice pursuant to this. So that's where we came down on that. So yeah, the knowing your technology and knowing that you can go in and change your settings to anonymize your view of social media is really a key takeaway here.
Yep, that's very important. And it's funny, the opinion closed with an interesting comment, which on one hand seemed to be a little bit off the basic part of the opinion, but it's worth noting. The Rule 3.3 has a provision that if a lawyer knows that a party is basically committing a fraud on the court, the lawyer has a duty to disclose that. And so the comment was, if in the course of doing a social media search, the lawyer discovers information about the juror, say information they should have discovered during voir dire and did not, the lawyer has a duty to disclose that to the court, even if it's to the disadvantage of the lawyer's client. That's an absolute duty to disclose. So that's worth keeping in mind. Keeping on sort of the technology track, the next opinion I wanted to touch on relates to, it sort of made me chuckle. I mean, you can envision this being much more a smaller firm issue. I mean, I think we are blessed with the fact that we have such a robust technology department here and such good folks working for us, and we've taken technology seriously, from the beginning. But the inquiry in this case from the lawyer was, it happened to be, I've got a bank client. The bank has upgraded its security systems. They're now requiring me to communicate with them with this new high-fangled security system. I'm going to have to, install new stuff in my office, and it's very expensive. Do I really have to do this? and totally aside from the client development side of things, yeah, if, if you want to keep the client, you have to, what's the answer from the ethical side of the equation? And it's a little broader than particular questions, so it's worth talking about. Going back to our old Rule 1.16, the confidentiality rule. The one of the provisions requires that we have to take reasonable efforts to prevent inadvertent and unauthorized disclosure of access to or information related to the representation. So bingo. This keys in old Rule 1.1 again. We have to make ourselves reasonably intelligent or reasonably smart, understand how to protect the confidentiality of our clients' information, and then take steps to make sure that we don't disclose it. And the ABA comment on the rule, specifically, notes that, if a client says they want you to use higher level of security, you got to do it. The opinion, interestingly, notes that the cost of the upgrade doesn't have to necessarily land on the lawyer. If the lawyer thinks it's a cost that's directly related to one client and no others, they can conceivably pass the cost on to the client. But again, I question whether that is a very good business development practice to ever get it started. Although, it wasn't that long ago where, we used to charge clients, for, I mean, we still do. I mean, we charge for copies, we charge for telephone calls and things like that. And some people argue that maybe that shouldn't be broken out on bills, and some lawyers clients complain about it. Um, um, the opinion also kind of generally discusses our Rule 1.6C obligations to prevent disclosure. In this area, it's important that there's no hard and fast list of things that you have to do. Check the boxes and okay, you've done enough to show that you complied with Rule 1.16 regarding the protection of your client's confidential information. But this is one of those awful situations where, it's a facts and circumstances kind of a balancing test, and you really have to assess the risks of what are the risks of information being disclosed? What are the kind of measures can be implemented? What's the cost of those measures? How effective will those measures be? And then once you do that balancing and come to a decision as what you have to do, you have an ongoing duty. You've got to, if you just buy a certain system, you got to make sure that it's working and it's installed correctly. You've got to update it. And whenever a patch comes out, you got to install the patch. You can't simply say, "Oh yeah, I put that in 5 years ago," and that's sufficient. So again, it's if you're technologically savvy, great. Keep on top of things and keep up to date. If you're not, you got to hire someone to advise you so that you know what you're doing. The next opinion, and I thought I'd touch about on. It's just it was interesting because it took the committee a while to work through the details and come up with an answer. But the headline question here was a lawyer. I've got my trust account. I try to keep all the records the way I should, but I've got this pile of old checks that we issued some number of years ago, and they've never been cashed. And I just keep carrying them over as nope, they haven't been presented yet. What do I do with them? Can I just turn the money over to my client now? Or what do I do? And it's a good reminder of our obligations relative to trust accounting. Here in New Hampshire, we've got Supreme Court Rule 50. I'm sure in Massachusetts and Rhode Island there are similar rules requiring, setting, really careful or comprehensive restrictions and requirements of what we do with our trust funds, the records we keep with respect to our trust funds, how we're supposed to, reconcile our trust accounts. And if you follow the rules and if life were perfect, you normally you would find and be aware of your stale checks. You'd follow up pretty quickly, find out why somebody didn't cash them, and get them cashed. But some fall through the cracks. It could be a witness fee for somebody. It was just so minimal. The person didn't want to, just forgot about it and didn't even bother cashing it. Could be a check somebody lost. It could be many different reasons. So in analyzing the question, the whole one of the first core questions could be is, all right, when you cut a check from the trust account, to be paid to a certain person, um, you know, who owns that? Who has that right at that point in time? Is it the payee and the payee forever, or adopting some of the rules, regarding stale checks and presenting of checks and all? Is there a point in time when a check is so stale that then it becomes non-active, and then if it, or not effective, and if it is, does that mean the money reverts back to the person who was the source of the money for the check? And so should the money be dispersed to that person? Um, and for those who are interested in such things, it's worth taking a look at that. But the headline here is, simply because a check is old and stale doesn't mean it can't be cashed, doesn't mean it won't be valid, and doesn't mean that a bank in good faith can't honor it. And so that the headline of the committee was, no, there's no clear point in time at which you can say, okay, that person forfeit the right to the money, therefore I'm going to disperse the money to somebody else, because you can almost guarantee that the day after you do that, the individual, the check's going to show up at the bank, present the check, it's going to flow through to your trust account. The money's going to be drawn from your trust account, and because you've already drawn it out and given it to somebody else, your trust account's going to be out of balance, and then you're going to be on IOLTA. In trust accounting problems, the Supreme Court. So the headline for this opinion is, first of all, follow Rule 50 strenuously, keeping track of checks that haven't been cashed, chase them down quickly. If if you happen to have some of these, you've got to make a good faith effort, try to find the persons, encourage them to cash the checks, encourage, clean up the funds. And if unsuccessful, probably the only safe avenue for a lawyer to follow to avoid responsibility would then be following the state unclaimed property statute, and essentially escheat the funds to the state after you follow the statutory process. The committee just issued another trust account opinion that is similar to this, and so I thought I'd do the two of them together. And it relates to the fact that the IOLTA accounts are very popular, became very popular a number of years ago by the courts and states, as a way to generate funds to do good things, in a legal context, but without raising taxes or having to raise the funds elsewhere. And, basically what they said is, okay, we got all these lawyers that have been holding all this money in trust accounts. And under the old rules, if you were holding funds for only a short period of time, you didn't have to put them in interest-bearing account. You took the money in, you held it for a week, then you dispersed when the settlement documents were signed, or you received them in on Thursday and you closed the loan on Friday, or whatever it might be. And we used to have, for short-term funds, we had no obligation to put client funds in interest-bearing account. Where the whole IOLTA concept was, the court in New Hampshire is no different, and I didn't check Massachusetts and Rhode Island, but I wouldn't be surprised if they have something similar. Lawyers are now required to have an IOLTA account in which all funds, of a nominal amount that are going to be held for a short period of time will be deposited. The change here is these IOLTA accounts are interest-bearing accounts, and so then the court order instructs the banks to forward all of the interest earned on these interest-bearing accounts to the court, and then the court uses it to, fund the Bar Foundation and other activities. So, the issue raised by this opinion is, okay, what is nominal amount and what's a short period of time? There is, and there are no definitions in the rule. There's no instructions, in the rules on this, and there's no guidance. Um, when we were discussing as the committee, in some ways it's sort of like the kind of the pornography and a discussion, that it when you see it, but what's nominal for somebody might not be nominal for someone else. You may think when you take the money in, it's going to be only there till next week, and then there's a glitch in your closing, and in fact, some hazardous waste has to be cleaned up, and it's 6 months later, and then you're finally closing the deal. To somebody, $10,000 is a huge amount of money. To some huge business, it's got to be $1 million before it really rings the bell on their ledger. So the decision also talks about say lawyers just having to do kind of a cost benefit analysis, if you will, when considering whether or not they're required to put funds in an IOLTA account. For instance, is there going to be a bank charge associated with depositing the funds in a separate account? How much money might be earned for the period of time it's going to be held? A lot of firms, I learned in this process, charge an administrative fee to clients to hold funds in trust. And so if the law firm's administrative fee charge is, compare that to what the funds might earn if they're in an interest-bearing account, you'll go through all that process. But at the end of the day, there's a recommendation, discuss with the client, make a good faith judgment, how long the funds are going to be set aside, how much the funds are. And then I try, every time I'm going to put money in, I have a significant chunk of money that will hold for a period of time. I'll talk to the clients and I say, look at, we can put it in the IOLTA account. You'll get nothing on it. I can put it in a savings account and you'll get a 0.5%, for 2 or 3 months, whatever it is, does it matter to you? And, if they say it doesn't matter, it's just as easy for me to throw the money in the IOLTA account rather than have to call Linda up and have Linda open a whole separate account for us to track, so that at the end, the interest earned goes to the client. Okay, and I think it looks like the timing is going to work out pretty well. I think I will, probably wrap up. The last opinion I want to talk about, is an opinion regarding municipal representation conflicts that gave me the fits, because every once in a while you get something that, the issue is so clear to you, you can't understand how somebody could possibly disagree with you. And in this case, the ethics committee was split pretty much down the middle on this. I still to this day do not understand the logic of the folks who are on the other camp on this issue, but it's worth putting it out there. The opinion was issued, and it's just good to think about because it conflicts of interest. So what we got here is, I think I can give you the facts pretty simply. Town attorney provides advice to the planning board regarding the interpretation of a zoning ordinance, a particular provision. So the planning board's confused. They say, we need help. What does this mean? How to interpret? How might this apply to this particular application? So the planning board takes that advice, makes a decision, and issues a decision on the application using that advice. Under our state law, if somebody wants to appeal a planning board decision that interprets a zoning ordinance, you first have to appeal to the zoning board of adjustment. And it acts as a first level of appeal before you go to the court system. So in this case, so the attorney advises the planning board makes a decision. Now applicant appeals that decision to the ZBA. The question was, can the town lawyer advise the ZBA on the handling of the appeal of the planning board decision? And as I said, the committee was split on this. I was in the camp that said, hell no. You know, the attorney advised the planning board, gave his or her advice to the planning board. The planning board took that advice, rendered a decision. The planning board's decision is now being appealed to what is essentially an appellate body. The town attorney has a duty to defend the planning board's decision before that appellate body. There's no way on earth the lawyer, the same town council can then turn around and provide independent, dispassionate advice to the ZBA relative to the appeal. You know, if on one hand, you know, and the sort of the worst case way to tee this up, let's say that if the town council advised the planning board, you know, that the ordinance should be interpreted a particular way. The planning board did not take that advice and interpret it a different way. So on appeal, the lawyer will have to defend the planning board's decision to reject the lawyer's advice and determine it differently, and at the same time advise the ZBA as to what the proper interpretation is of the ordinance is on appeal. But in advising the ZBA, the lawyer obviously will be ethically prohibited from undermining the planning board's position that was contrary to the lawyer's position. So, you know, it seemed to me that it's a completely, you know, absolute conflict. There's no way that one lawyer, and, you know, most of the municipalities we've dealt with, when this happens, the municipality will actually hire a separate counsel to, you know, represent the ZBA to avoid this. Or in the case of the city, they've got more than one attorney in their city staff, and they kind of do a Chinese wall thing, and one of them handles the ZBA, one handles the other side. You know, as I said, there were two camps on this. You know, putting the argument for the other camp in the best light. They kind of view, they look at both, you know, both the boards really aren't separate entities. They're part of the same municipality. They have language that talks about both boards have a common interest in consistent and lawful interpretation of the ordinance. There's no direct adversity between the boards. There's an assumption that the lawyer is going to provide consistent advice to both of the boards. So how can there possibly be a conflict? You know, it's a very Pollyanna-ish view of things, but of course, if all of that were true, you would never need a ZBA to review and possibly overrule a planning board decision. So I remain baffled by the second camp. The good news is, you know, the first camp, my camp, you know, was able to get the decision massaged enough so anybody who reads it knows you've got to be absolutely nuts to represent both boards. It's a bad idea, but it's just a, you know, a good reminder how, you know, again, that was focused by, you know, a municipal council attorney, but, you know, it can happen so easily, you know, in the context of our own private practice. You know, if we've got clients with multiple entities or subsidiaries, or, you know, if we have a business, you know, small businesses where, you know, an LLC has 2 or 3 partners, they start squabbling. Who do you represent? Where your interests lie? You know, that it's the same kinds of issues. You've always got to stop, you know, reminding yourself, who's the client? Who am I working for? Where are my loyalties? And can I dispassionately and in a disinterested way, you know, represent this new entity without limitations on my abilities to represent them? And I am at the limit of my time, over a minute or two. And so I joked I wouldn't be able to talk enough, but I guess the joke's on me, Kevin and Meg. I did use my time. So Meg, it's all yours.
All right, very good. Well, good morning, everyone, again. I'm going to be talking about professional discipline cases over the last year, not only in New Hampshire, but in some of the other jurisdictions where we have offices. And then I'm going to talk briefly, I think, about some ABA opinions that seem pertinent to our practice. So we'll start with the discipline cases. And I guess I would say by way of introduction that this was a relatively, we're going to start with the ABA opinions. Well, we could do that.
Where do you want to go, Meg?
This is fine. Let's
Okay.
do these, and then we can close with the discipline cases.
Okay.
While we're on there we go. On the ABA opinions, they are, as I think everybody knows, they are commenting on the model rules of professional conduct and providing some general guidance on those rules to practitioners across the country. In New Hampshire, and I think virtually all the New England states, the model rules are the foundational rules governing ethics and professional conduct issues. However, each state from time to time has adapted the rules for their own purposes. And you have to be mindful of that as you look at these formal opinions, because the rules in a particular state may vary somewhat from the model rule that the ABA is discussing, but nonetheless, they can provide, helpful guidance on professional ethics issues. And so many courts, including, certainly the New Hampshire court, will look to them for guidance, but they will not find them dispositive, just as they do not find the opinions of our ethics committee necessarily dispositive, but they certainly take those into account as they reach their decision. So let's go to the first opinion. The ABA opinion 488, which was just issued a short time ago, it discusses the standards for when a judge should disqualify himself or herself as a result of a relationship with parties or counsel. And fortunately, the analysis that the ABA reached in this case was relatively similar to what our own New Hampshire Supreme Court has already decided in an earlier case of its own, governing issues such as this. And the court or the ABA, in looking at this issue, was trying to provide some guidance to judges as to when they need to consider either disqualifying themselves or putting all parties on notice when an involved party or representative is either an acquaintance, a friend, or someone with whom a judge has a close personal relationship. And they go through a good analysis of sort of the tiers of relationships. And, obviously, bright line, if you have a member of your own family or someone that you have such a close personal relationship with that it would affect your independence and judgment in deciding on the case, then that will require disqualification. However, the court went on to say, or the ABA went on to say, that there are tiers of friendships and there are tiers of relationships, and that and this is, I think, is particularly relevant in states like New Hampshire, Vermont, Maine, where the bars are relatively small, people tend to know each other. And even in Massachusetts, I think there are many bands of connections. So the ABA was careful to note that all friendships are not equal, so that even though you may have a judge may have a social relationship with a party's counsel, that does not necessarily require disqualification. It may warrant disclosure of the relationship so that anyone who does have a concern can properly raise it. But it's just good practical guidance and something to be mindful of if you are in a situation, in a case where you think that this may be a circumstance that you want to at least discuss with your own client as to whether or not you should seek disqualification in a particular case, to just be mindful of that. So I think we can move on to the next slide, Kevin. Opinion 489, deals with the circumstance that we're all now very familiar with when attorneys are moving between firms as to the proper protocol and techniques and procedures that should be followed when a lawyer is moving between firms. The ideal scenario that the ABA proposes is for the departing lawyer and the firm to work together to provide prompt notification to clients of the lawyer's intended departure from the firm after the law firm has been notified, I would say. However, the ABA went on to say that if the firm and the departing lawyer cannot reach agreement on the terms of a joint communication to clients, which is the ideal, the lawyer is permitted to reach out to those firm clients with whom they've had significant client contact. And obviously that's the critical term that the ABA is trying to provide some some guidance on. Significant client contact under this opinion means a client who could identify the lawyer by name. That seems pretty basic, as one of the attorneys representing the client. It doesn't include a client for whom the lawyer only prepared research memos for another attorney or did some background work but didn't speak with the client. I think that can be helpful in a particular situation, to be mindful that all client work, all work done for clients does not necessarily mean that a departing lawyer is entitled to have a choice letter sent out. And for those folks, I think most people on the Zoom are familiar with this, but the joint communication when a lawyer is departing a firm is to advise clients of the departure and to give the client three choices, basically: either to remain with the law firm if the law firm feels that it can continue to, properly represent the client, to go with the departing lawyer, which is obviously usually the departing lawyer's strong interest in having that happen, or to choose another lawyer and just say, I want to move on and do something different. So this circumstance is something that happens now quite frequently, and it's good to have some guidance. The committee also noted that departing lawyers cannot be held to a fixed notice period, so that you can set a certain parameter of time in order to make this notice to clients and to get their response. And the committee took into account that across the country, really, many cases have arisen in which any circumstance in which law firms try to impose financial disincentives on a lawyer leaving the firm and seeking to compete have routinely been struck down. And bottom line, both the firm and the departing lawyer have to be mindful that that the requirements imposed by the law firm on a departing lawyer cannot unreasonably delay the diligent representation of a client. So, for instance, you can't hold up transferring of the file to a departing lawyer if that could have an impact on representation of the client. So, moving on, the next opinion that I'm going to talk about briefly is ABA Formal Opinion 492. And I think Kevin or Peter referred to this earlier. This concerns prospective clients, cold calls, and confidentiality, and tries to provide some guidance as to when contact with a potential client that doesn't result in a formal attorney-client relationship can create some ethical issues. The relevant model rule, and I think it's mirrored in New Hampshire and I believe in other jurisdictions in which we practice, is Rule 1.18. A lawyer is prohibited from accepting a new matter if the lawyer received information from the prospective client that could be, quote, significantly harmful in the new matter, and that's the relevant standard that the ABA opinion is addressing. The committee sought basically to make it clear that the types of circumstances that would create this, the prospect of significant harm. So if you can move to the next standard, it's very much factually based and requires, sort of a very specific analysis of the type of information that you receive in this initial call, the kinds of circumstances that the committee took into account that could be considered significantly harmful would be when the potential client discusses with the lawyer views on settlement terms, his or her factual interpretations or strategic thinking about the claim. If the lawyer in this initial call were to offer advice regarding potential claims and discussions of settlements, or there's a discussion about legal theories regarding a proposed lawsuit, or the prospective client offers any kind of sensitive or confidential information about his or her claim or business. The committee noted that certain types of information won't be considered significantly harmful, and they would include embarrassing facts or conduct, inconvenient information for an opposing counsel to have, and general and public information about the prospective client. So the headline of all this, I think, should be very careful when you get a cold call from a potential client about how extensive a discussion you have with that prospective client before you decide whether or not you're going to undertake representation, because you may mean well, you may want to get enough information to help you make a decision as to whether or not you should form an attorney-client relationship with that entity, that person. But the end result could be that if you get too much information too soon, you may have created some ethical challenges down the road for either you or one of your partners if you decide not to take on that representation. So practical advice is just limit yourself as much as possible. I expect perhaps when we talk about the SurePoint guidance conflicts checkbook, we're going to talk a little bit about how we can put these kinds of contacts into our conflict database system so no one's surprised, because one of the worst things that can happen is for you not to take a case because you decide you don't want to take on that particular matter. One of your partners gets involved in representing another party in the transaction or the litigation 6 months down the road, and the next thing you know, there's a motion to disqualify. So forewarned is forearmed.
I think Rob has his hand up.
Yep.
Yes, I have a question, Meg. How do you deal with the situation where you get a letter, an unsolicited letter from a potential client who says, dear Ms. Delaney, I heard your name through so-and-so. Here's my situation. And they outline factual information about their potential claim, for example. And you know you are not going to take that claim or that case, but you now have received this confidential information. Is that something you would put into conflicts as a potential issue so it gets spotted? And B, how do you deal with the potential of therefore being disqualified from representing, Concord Hospital when I get the letter from someone complaining about the care that was provided there? Do you have some advice on that issue?
Yes, I think first off, if you got a letter with this long complaint, I probably would, and I'd be interested in Kevin and Peter's thoughts on this. I would have a written communication back to the person saying, thank you for your unsolicited, communication. I'm not in a position to assist you, and I am not, this communication doesn't create an attorney-client relationship, and I'd urge you to seek guidance from someone else so that you have a clear written acknowledgement that you are not accepting that as any kind of even beginning of an attorney-client relationship. I'd leave it to Mr. O'Shea perhaps to speak about whether that should be identified in the conflicts database. And there are circumstances that I think we're all aware of where sometimes And I can think of a situation that arose, some years ago where a very angry, very disgruntled former doctor, a very embittered plaintiff, basically bombed all potential, law firms with a lot of information about her claims that I think was a fairly transparent effort to try and set up disqualification of a lot of people. So you got to be mindful of that. We do have, I think most people are aware of this, we have disclaimers on our website that makes it clear that just because you want to send us a lot of material doesn't necessarily mean that we're going to become your lawyers as a result of that. But you still, this model rule makes it clear that even those disclaimers alone are not going to absolve you of some responsibility if you do come into possession of significantly harmful information. I mean, the rule does speak, of course, in terms of, or the opinion here does speak in terms of allowing appropriate screening when you've had some contact, but you've made it clear there's no attorney-client relationship going forward, and the information you get isn't significantly harmful, that there can be an appropriate Chinese wall set up. But I don't know if Peter or Kevin want to say anything more about that right now.
Yeah, I'll make 3 quick observations. The first observation is never underestimate the value of a declination letter. I actually have a sample of, there are different declination letters for different purposes, but I have one for really unsolicited contact that makes it clear we're not taking a claim, we're not doing anything for you, and also makes it clear that that it was unsolicited and we didn't ask for any information that you provided us. I believe, I'm like 80% sure, but I will follow it up and circulate something that when the information you receive is unsolicited, you have greater latitude to accept the case later on, or someone in your firm has a case to accept it later on, because you in fact did not solicit. We really can't be put on, if the standard were simply, I'm gonna Zoom bomb you, for lack of a better words, with information you didn't ask for, that's a very high standard, but I will double check on that, but that's my recollection. And the third issue is with respect to conflicts, I think you have to use your judgment. If it's an unsolicited contact, which appears to have, is just a random email from someone that's, peddling undisclosed work, I generally, like most people, view that as spam and don't deal with it. But if it has detail about someone to be a known client, or otherwise has sufficient information that makes you think that this person they could come back and bite us, for lack of a better word, then I think it belongs in conflicts, not because it is a conflict, but it should be something that the second attorney who gets the inquiry from the potential defendant or adverse party should know about in deciding to take the case, and avoiding that disqualification down the road. So I think those are my 3 observations.
Yeah, I would just echo the last comment you made, Kevin. I with respect to those conflicts, in my view, the vast majority of the situation is not going to involve a conflict or even require any type of significant conflict analysis. It's just a heads up to someone else down the line that, this information is out there that they should be aware of, just so that they're prepared. So thank you.
Yeah, I might add, just to show that I'm still awake. There's a New Hampshire Ethics Committee comment on the rule too that really addresses Meg's question. And it says, it basically says not everybody who communicates information is necessarily a prospective client, especially if they do it for the purpose of disqualification, or if they do it with no reasonable expectation that a attorney-client relationship will follow. So that, if I think that gives a lawyer the ability, if somebody is just bombing every single, defense firm in the state with a bunch of information to disqualify them, that won't disqualify you necessarily. But, on the point Kevin was making too, that I think that there is an important line, on one hand, if somebody just bombs you and you don't do anything with it, maybe it doesn't get into our system. But absolutely, if you talk to somebody and then decide not to take the case, that absolutely has to go into the system.
Yeah.
And even, and this is a little bit harder, but I mean, I think if we're to be careful, even if you have a material conversation with a friend or somebody at a cocktail party, you know, at the beach, at the lake, you know, over drinks at margaritas, you need to seriously consider whether that pops in the system, because you guarantee those are the kinds of things that, and I think we have an ability to put in, you know, potential relationships, you know, not that they were a client, but it was a one-time contact is what we used to call them. I don't know what we call them now, but just a pointer there.
Can I, with great respect and affection for Meg, can I hijack this for a second, and can we jump to the piece about the SharePoint, because I think there's the extent to which we're going to be sly on time. I don't want to give this short shrift while we have folks here on the line.
Totally agree.
All right, let's see if I can.
He who is screen
Go.
sharing controls the presentation.
This is a little dizziness inducing, but go ahead. I think you rolled past it. Here it is.
I did. So we actually had this issue on the ethics committee recently. You know, one of the issues about conflicts and about setting up new files is really what would appear to be the simple question: who is the client? And one of the things that we want to make clear is, at least under New Hampshire law, although other states are different with respect to the tripartite relationship, it's unclear whether a carrier is the client. And so as a result, one of the things we want to make sure that, and Steph did a lot of work on this, as well as did Chris, so I invite them to jump in as well. When you're setting up files, you know, it may be the case that we functionally group the client, lowercase c, by the carrier, but that doesn't absolve or change the analysis that the insured is always the client, and what duties we may have to the carrier may result by contract, may result by the form of the engagement. But we should never confuse the fact that we are functionally grouping clients by their carriers in terms of who is the actual client. I'll let anybody else who wants to jump in on that. Okay, I'm a man on an island. I will go back to slide 100 and let Meg continue.
All right, the next opinion, ABA Formal Opinion 493, deals with Model Rule 8.4G, and the goal of which is to establish a duty to refrain from engaging in harassing or discriminatory conduct, at least with respect to the practice of law. The obligation specifically under this opinion doesn't limit, you know, sort of an attorney's free speech rights in matters unrelated to conduct. This is, again, an area where Peter should chime in, because this rule took on a life of its own and became highly controversial in New Hampshire, leading to, you know, much debate and argument. And so some of this model opinion is really not particularly pertinent to New Hampshire. I am not sure that the debate in other jurisdictions in New England where we practice was quite as heated as it was in New Hampshire, reflecting sort of our ornery, live free or die, you know, personalities up here. So the rule, the model rule, prohibits a lawyer from engaging in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, sexual orientation, marital status, or socioeconomic status related to the practice of law. Seems laudatory enough. However, it became controversial, as Peter will bring us up to date on. The scope of the model rule covers two particular types of conduct: harassment and discrimination. Harassment is conduct that is aggressively invasive, pressuring, or intimidating, and discrimination is harmful verbal or physical conduct that manifests bias or prejudice towards another person. The goal of this, I think, was laudable, was to, you know, and consistent with the basic rules governing sort of both underlying the rules of professional conduct and sort of professionalism standards in the practice generally. And as the opinion notes, courts have consistently upheld professional conduct rules similar to the model rule against First Amendment challenges, because that's where the rubber sort of hits the road. Does this somehow impose restraints on an attorney's First Amendment rights, or otherwise really affect their constitutional rights simply because they hold a license to practice law? And the courts which have dealt with this have said no, because they're focusing just on that area where these potential claims are related to the practice of law. Peter, maybe this would be a good point for you to talk about, briefly the history of 8.4G. I know we've talked about this in earlier programs, and maybe you can just bring us up to date on the status of this rule in New Hampshire.
Sure. It's interesting. Probably this is the first time in about 4 years I haven't talked about 8.4. But yes, it was adopted by our Supreme Court. A version of it was adopted 2 years ago. And the reason I know that is I just had a little tickler come up on my calendar to remind me that the 2-year anniversary was coming up, because when the court adopted the rule, they instructed the ADO to review the implementation of the rule for 2 years and then report back as to how it went, to see if all of the nasty, terrible stuff that the opponents predicted would happen was happening. But as of right now, I mean, I think here in New Hampshire, it's been very quiet. The rule's been in place. I haven't heard any issues about, efforts to change it. The New Hampshire version included some language that really makes the rule almost meaningless, even though the words are there, because of the way the court changed it. But the rule, just a footnote, nationally is has turned into a real hot button issue. Just like so many things these days, it appears to have become, one of those polarizing things, kind of like masks, where people fight about it to the death when, as you said in the beginning, Meg, I mean, who can argue that lawyers should be professional and shouldn't harass or discriminate? But the primary fight against it is this First Amendment challenge that it's going to limit lawyers' right. It's going to prevent lawyers from freely speaking. And the interesting observation from my part is, it is coming from the conservative right. And maybe it isn't surprising. It's, I think it's part of this fear that the liberals are going to take over and tell us what we can and can't say and how we can behave, and therefore we're against it. So the Federalist Society and some very, very high-powered groups like that are very much behind the efforts in the states to either oppose it or to get it repealed. And in fact, I think in Pennsylvania, a federal court, basically said that the rule as adopted in that state, was unconstitutional, and I think that's being appealed. But as of right now, things are quiet here in New Hampshire. We have the rule.
And I don't know if anyone who's practices largely in Massachusetts or Rhode Island have had any other experiences. Maybe if we have some time left over for questions at the end, we can talk about that. But I think we're ready to move on probably to the next one, lawyers working remotely. The ABA has issued its opinion 495 on this issue, just as most people are hoping that they can return from remote work, but better late than never. And again, it's very consistent with many of the comments Kevin offered earlier about dealing with technology and Zoom. But this, and this is of particular interest in me, to me, and perhaps to some others, that they also deal with some other issues relating to remote work, particularly remote work outside the state in which you're licensed, and Model Rule 5.5, which I think is in effect in, certainly I know, New Hampshire, and I believe Massachusetts, and probably Rhode Island as well. You're prohibited from engaging in the unauthorized practice of law, but that does not preclude a lawyer who is physically in one state where he or she is not licensed from continuing to offer legal services in a state in which they are licensed, so long as you don't hold yourself out as a licensed attorney in the state in which you're not licensed. And if those services reasonably relate to the practice in their licensed jurisdiction. So this was obviously an issue that came up as people dealing with the pandemic, remove themselves from the states in which they were practicing to get usually to go home to be with mom or to be in a safer environment. And the committee felt that it was important to speak to that. And as I noted, has concluded that remote practice does not inherently violate Rule 5.5. However, they caution that you need to take certain good practical steps to avoid inadvertently indicating that you're practicing law in a jurisdiction in which you're not licensed. So again, part of the great body of law that is going to be viewed as pandemic related, I guess.
I might just add on this one. In a way, this is a real trap for the unwary. In New Hampshire, several years ago, pre-COVID, we actually, liberalized our Rule 5.5 to specifically acknowledge that a lawyer practicing in the state, but only practicing law in another jurisdiction, doesn't violate the rule. And that was really, it was an outlier at that point in time, because most of the states still had the old rule. If you were there and you're a lawyer, you're practicing. So this is, one of those nice situations where we can say the AB is finally catching up with us. But the reason I say it's a trap for the unwary is you just, you got to remember that when we're traveling, it's not the rule of our home jurisdiction that counts. It's the jurisdiction where we're going or where we're practicing. So it's wonderful for New Hampshire to have a very liberal rule, possibly Massachusetts or Rhode Island, but, places that are very protective of their bars, especially I'm going to say Florida, you would want to be, you need to check and see what the local rule is and the local interpretation to make sure that whatever you're planning to do makes sense and is permitted.
Agreed. Next ABA formal opinion, I think probably the last one in this package, again, is part of the body of law arising out of the pandemic, technological advances in the practice of law, virtual practice, and the opinion generally discusses ways to make sure that your virtual practice conforms with your ethical duties. And much of it, I think Kevin has already touched upon in his earlier conversation, but why don't you advance the slide, Kevin? Again, there's a discussion of the key rules, 1.1, 1.3, 1.4 in terms of competence, diligence, and communication with clients, and the importance of above all, maintaining confidentiality, which all of us who practiced at home over the last year had to learn, to keep your door shut, make sure other people weren't in the room when you were having conversations, and then take steps to make sure that lawyers working with you or your assistants who are also working from home were complying with those rules. So you have to keep up to date on the technology, as Mr. O'Shea has told us numerous times, or find somebody who can do that for you. You have to consider all appropriate safeguards for client information, securing emails, and make sure that everybody on your team is mindful of all this. And again, the importance of knowing what you're talking about in terms of technology, or making sure you understand how to implement good security protections is very important. We're very fortunate, as everybody here has alluded to. We've got tremendous resources in our IT department. We have Kevin and others who are very knowledgeable about these kinds of issues. So we are in very good shape, I think, on these issues, but we can have all the protocols and policies and resources in the world, but we've got to implement them on an individual basis. But I think it seems to me we've all navigated the last year pretty successfully. So I think we've all done that. But good to know about these opinions, because they give you a good, useful checklist on things you should be mindful of, because even as we emerge from the pandemic, it seems clear that some form of hybrid practice, virtual practice, is probably going to continue as we move forward. So very briefly on New Hampshire, on some discipline cases from across New England that occurred over the course of the last year. And I would say, by way of background to this discussion, that there are relatively few of them, which largely, of course, is related to the pandemic and the limitation on litigation and frankly, the whole disciplinary proceeding process. I'm wondering if this will be similar to what occurred back during the time of the Great Recession, when I was still sitting on the Professional Conduct Committee. In 2008 and 2009, we went through a sort of economic cataclysm that led to sort of a limitation on many forms of, say, commercial litigation, as companies were in bankruptcy, had to work their way through the stays. Divorce practice, I know, was substantially affected because people literally could not afford to get divorced. And yet in the year or two after the recession began to ease, the professional discipline system, I think in New Hampshire and I think throughout the country, began to see a wave of professional misconduct complaints arising out of, in many cases, sadly, out of financial misdoings, as lawyers dealt with, the stress of what had happened during the recession by, in some cases, making very unfortunate decisions to, draw upon client funds to help them get through. Most of them with I think at least the initially sincere desire to that they'd make it up as their finances improve. But as many things happen, things snowballed and they didn't happen. Also, the stress of that whole situation relating to the recession produced, some problematic decision-making on cases that led to discipline cases. We'll have to see whether that occurs as a result of what we've been going through and the issues that Kevin talked about in his presentation about the stress that lawyers are under. Let's hope not. But in any event, let's talk about the cases that did exist and that were decided over the course of the last year. The Mesmer case, I believe this was discussed at a litigation meeting early last year before we all went to lockdown. Sleep apnea is not an excuse for failing to adequately represent your clients. This case arose out of a circumstance in which the lawyer was retained to represent a client in some litigation and told the client repeatedly that he was working on various pleadings relating to the litigation. But ultimately, as sometimes happens, the clients received a notice of default from the court, which brought to light the fact that the lawyer, in fact, had done nothing in connection with this case. And he had gone so far as to lying to opposing counsel about serving a responsive pleading that the opposing counsel had no record of in his files. As you can imagine, this all led to disciplinary proceedings, and in the course of that, the attorney tried to justify his conduct, or at least explain his conduct, by virtue of the fact that he was suffering from sleep apnea, and therefore he couldn't form the intent to violate some of the rules that he was charged with violating. The Professional Conduct Committee, and ultimately the court concluded that, in fact, that was not a sufficient basis to excuse him from his violation of these rules. The court made clear that in sleep apnea, while it might be a personal problem, it was not a disability that justified his violations of the rules, particularly because that condition, while it could perhaps have justified the fact that he didn't do the work he was supposed to do when he was supposed to do it, it never justified his dishonesty to his client, to opposing counsel, and to the court. So be careful out there. The next case, again, arises out of New Hampshire and is an illustration of how you can take what is a bad situation and make it 100 times worse by not cooperating. In this case, the attorney was placed on interim suspension after the attorney discipline office received complaints regarding his failure to attend hearings, failing to respond to clients and opposing counsel. He then proceeded to fail to cooperate with the ADO for information during its investigation or to participate in any way in 3 separate ADO proceedings relating to his conduct. The end result of all that, probably not surprisingly, was that he was disbarred. And so issues that in and of themselves could have been resulted in far less serious sanction resulted in the ultimate punishment. So the freeze frame is never a good idea. So next case, this case involves Julie Intricasso. It's kind of personally important or significant to me because I know Julie. This is a case of judicial misconduct, not legal misconduct, but I think it's still worth talking about because it illustrates, the sort of slippery slope that can end in disaster if you aren't careful. Julie, just by way of background for folks who understand this decision, she was for many years a deputy clerk in Rockingham County, very highly regarded. She sat for a few years on the professional conduct committee when I was still on the committee. And in fact, we thought highly enough of her that when our disciplinary counsel, who investigates and prosecutes complaints, moved on after a interview process involving other candidates, we selected her to be disciplinary counsel. And she served in that role for probably a little less than a year. And then she was nominated and accepted a position on the circuit court in New Hampshire. So she was, quite highly regarded during her time on the committee. She was always very practical, very focused on ethics. So how this circumstance that she's now confronting and that the Judicial Conduct Committee had to confront arose is just truly surprising to me. The long and short of it, there's quite a lengthy Judicial Conduct Committee statement of charges, but she signed some orders involving a case in which a friend of hers, a close personal friend of hers who was on her recusal list, was serving as guardian ad litem. And the initial orders were simply, approving recommendations of a marital master about the appointment of the guardian ad litem. And so to a certain extent, you could make a legitimate argument that these were sort of housekeeping ministerial acts and didn't really affect the outcome of the case. However, she then proceeded to sign some orders regarding payment of the guardian ad litem and the mechanisms, the means that one of the parents had to use to pay the guardian ad litem, whether she be paid by check or Apple Pay or some other mechanism that really got her much more directly involved in the substance of the case. At some point, she recognizes that this is a problem and she recuses herself in a written order. However, by this point, the disgruntled parent who didn't like the guardian ad litem to begin with had brought a judicial conduct complaint against Judge Introcaso. And at that point, as sometimes sadly does happen in these cases, bad went to worse. In the course of responding to the judicial conduct complaint or inquiry that was begun, Judge Introcaso, it appears, took the files in this matter and whited out portions of the order relating to the payment materials. There seems to be no good rationale for why this was done. And in the course of that, she had a number of interactions with court staff that led them to have additional concerns about her behavior. The upshot of all of this was that not only was she accused of violating the judicial rules of ethics, but she was also criminally charged with falsifying, court documents and other related charges. She has resigned from her position, and the Judicial Conduct Committee made a decision that it was best to resolve the case without a hearing. She is now suspended from practice, and she awaits, the outcome of the criminal proceeding. So this is a very sad and difficult situation. I think the lesson is, if anyone finds themselves in a situation where they feel they've made an ethical mistake or misjudgment, don't make it worse. Stop and think, reach out for some guidance, reach out to people on the ethics committee or someone you know and trust. Just don't let the situation snowball. This has happened not just for Judge Introcaso, but for many other circumstances that came up while I was on the PCC, and in many of these cases that we're talking about, where people could have solved the problem, but for some reason they just let it get worse. And we have resources available to prevent that from happening. So please take advantage of them. Next case. Here's a pretty easy one. Don't use your client's funds to pay for your firm's operating expenses or your mortgage. Client's money is the client's money. Your money is your money. It's very important. This is a case that arises out of Massachusetts. You got to keep those two things separate. Again, this is another situation where people should have learned from the past. They had a problem with an earlier financial officer for the firm covering firm expenses, with client funds that were on deposit. They became aware of that situation. They fixed the situation, but nonetheless, the situation kept reoccurring. As a result of that, the lawyer was disbarred. And this is a case, Ablett out of Massachusetts. Don't try to work extra terms into a settlement agreement. Again, a case out of Massachusetts. If you reach a settlement with opposing counsel, you can't then try to insert additional terms into the agreement, sign it on behalf of opposing counsel, and send it to the court. That is not acceptable. And I think there's nobody on the Zoom who is going to do anything like that. But the end result of that whole process for Attorney Levine out of Massachusetts was that he accepted liability and resigned from the bar. I would note that Massachusetts has somewhat more generous standards to allowing people to resign from the bar when they're facing discipline proceedings than New Hampshire does, though New Hampshire itself has relaxed their rules a little bit. But in any event, don't do that. And a perennial favorite that often comes up, it's still not okay to sleep with your client under virtually all circumstances. This case involved a reciprocal disciplinary claim where a lawyer had been disciplined in New York because he had engaged in inappropriate sexual relations with a client. the issue then went to Massachusetts, where he was also barred, and they found reciprocal discipline was appropriate, even though I will note that he and Massachusetts did not have the same rules as New York. New York had a specific rule precluding sexual contact with clients. Massachusetts did not, but they applied their standard conflicts rules to apply and justify the reciprocal discipline. Again, this is another case coming out of Maine. Basically the same principle: can't have sex or inappropriate contact with your clients. This attorney sought to defend himself on some very, let's just say, non-woke arguments that, basically the woman was enticing him, and that didn't work out too well for him, and he was suspended for a number of years by Maine. However, they did take into account that toward the end, he did seem genuinely remorseful. So they did give him the opportunity to seek reinstatement, but after a very long period of suspension. Again, I won't spend too long on this. You can't, financial matters are something that are very important to be very careful and precise about. We have very good systems in place at the firm to prevent this from happening, but you can't breach your fiduciary duties when you're dealing with clients' funds. And so that's very important to bear in mind as you, make decisions about how to handle funds that clients have entrusted to you. Have to be careful about conflicts with former and current clients when you're seeking unpaid legal fees. This is a case that arises out of Vermont. Again, particularly in a marital situation, though it applies everywhere, you've got to be very careful to make sure that everybody involved understands who you're representing, what the circumstances are, and it be essentially fair to all parties when you're, particularly when you're seeking recovery of your own legal fees. The failure to do that in the circumstance of this case involving Attorney Bowen led to his suspension. We're getting up on 10 o'clock.
And I think we've reached the point in the slides that we've already covered. So I think
Yeah.
I just want to close it out by, sorry about that. There was a lot more to that conflict checking thing, but I think we covered it. The main other thing I wanted to say about the tripartite relationship is that because you have duties to the client, there may be a situation in which you have to do a noisy withdrawal if your conduct may injure the client. But I commend these slides to you. The slides will be available along with the materials. Amy will have them in a little while. Please, make sure that you email Amy so you can get your certificate. The deadline for CLEs this year is actually the end of May. So if you need more CLE credit, I believe our new Lexis contract allows you to get online CLE credits. And I also believe that the live in-class requirement has been suspended, so you can get everything you need online. And last, I'd like to thank Allison, who literally burned the midnight oil any number of times to help get this materials ready for us. So thank you very much for that. Any questions, comments, or concerns? I'd like to thank, of course, Peter and Meg for their contributions to today's program. Excellent stuff.
Very much thank Allison for her efforts in compiling all these materials, and hope very much that everybody takes a look at them, because there's a lot of very good detail that we weren't able to cover in our 2 hours. But thank you all very much.
Farewell,
Hey,
everybody.
Kevin, Peter, Allison, thank you, one and all. Really appreciated.
Take care, everybody.
Thank you.
Thanks all.